Latent defects. In the previous section, we worked through practical legal hotline-style questions and answers involving buyers, brokers, due diligence, solar leases, and the duty to verify information when concerns arise. That discussion leads naturally into the next question every licensee must understand. What exactly is the kind of defect that must be disclosed, and why do some property conditions create so much legal risk? Arizona's continuing education standards specifically recognize that disclosure training should include common material facts warranting disclosure, liability for failure to disclose, avoiding inadvertent non-disclosures, and warning buyers and sellers about common red flags. A latent defect is a defect that is hidden, concealed, or not reasonably observable during an ordinary visual inspection of the property. In real estate practice, latent defects are especially important because they are often the defects most likely to surprise a buyer after closing. A buyer may walk through a home several times and still never discover concealed mold behind drywall, long-term roof leakage inside the attic, unstable soil conditions, hidden plumbing leaks, prior fire damage behind cosmetic repairs, or structural movement covered by patchwork and fresh paint. Some latent defects are known by the seller, and some may not be fully understood by the seller. However, when a seller or a licensee does know about a latent defect that materially affects the value, desirability, or safe use of the property, silence can create serious liability. Arizona disclosure law has long focused on whether the fact was material, whether it was known, and whether it was not readily observable by the buyer. A helpful way to think about latent defects is to compare them to obvious defects. If a buyer walks into a room and sees shattered windows, missing flooring, and exposed ceiling damage, those conditions are not hidden. They may still be important, but they are not latent. By contrast, if the wall looks normal, but mold is spreading behind the water heater, if the roof appears fine from the ground, but has a long history of leaking into concealed spaces, or if prior water intrusion has been painted over without full remediation, those are the types of issues that may qualify as latent defects. For example, imagine an investor who is flipping a manufactured home and is also acting as the listing agent. During repair work, the investor sees a small patch of mold hidden behind the water heater. Later, when the home is listed and sold, that mold is not disclosed because the investor believes it is minor and not worth mentioning. That is a dangerous decision. Even if the mold appears limited, the agent investor has personal knowledge of a hidden condition that a buyer would not likely discover during a normal visual walkthrough. If the condition later turns out to be more serious, the failure to disclose may become a central issue in a lawsuit. This is especially important for licensees because Arizona professional conduct rules continue to place emphasis on the duty to obtain and accurately communicate material information relevant to the transaction and to help clients address red flags through proper investigation and disclosure. The 2025 ADRI modernization also reaffirmed that disclosure education should address common material facts, warranting disclosure, liability for failure to disclose, inadvertent non-disclosures, and red flags. Common source of lawsuits. One of the most common sources of post-closing litigation in residential real estate is poor disclosure. Buyers often file claims not because a property had a problem, but because they believe the problem was known and not properly disclosed before closing. A house can have defects without creating a lawsuit. What often creates the lawsuit is the belief that someone knew more than they told. This is why disclosure disputes are so fact-sensitive. Buyers may argue that the seller knew of repeated roof leaks, prior water intrusion, termite history, drainage problems, title issues, unpermitted additions, or neighborhood impacts and failed to reveal them fully. Sellers may respond that they did not understand the seriousness of the issue, that they thought a prior repair fixed the problem, or that they did not believe the information was material. Brokers may then be pulled into the dispute and asked what they knew, what they observed, what they recommended, and what they documented. From a risk management standpoint, one of the strongest defenses in a disclosure case is a well-completed seller's property disclosure statement, SPDS, supported by documentation showing that the buyer received it, reviewed it, and had the opportunity to investigate further. Arizona's disclosure-focused CE standards specifically emphasize the scope of the licensee's role in the client's review of disclosures and the importance of warning buyers and sellers about common red flags. A lawsuit also becomes more likely when a broker notices a suspicious condition but says nothing. For instance, if a licensee sees patched ceiling texture, warped baseboards, cracking stucco around a window line, or an obviously altered grade that suggests prior drainage issues, those observations should not be ignored. A broker is not required to become a structural engineer or mold specialist, but the broker should recognize the red flag, point it out, recommend further investigation, and document that recommendation. In practical terms, the best approach is not to ask, "Can I get away without mentioning this?" The better question is, would a reasonable buyer want to know this before deciding whether to proceed? If the answer may be yes, disclosure and further investigation are usually the safer course. Seller disclosure form topics. Seller disclosure forms are designed to help organize information that a buyer would reasonably want to know before purchasing the property. They are not intended to create fear or make every property look defective. Instead, they help move the parties toward a more informed transaction by prompting disclosure of facts that might otherwise be forgotten, minimized, or misunderstood. Most seller disclosure forms cover a broad range of topics involving the condition, history, use, and legal status of the property. These categories often include environmental conditions, water intrusion, drainage, mold, prior repairs, roof condition, heating and cooling systems, electrical systems, plumbing and sewer systems, appliances, irrigation systems, improvements, title issues, and hazardous conditions. They also often create a place to explain whether repairs were made, whether the condition still exists, and whether outside professionals were involved. This matters because many disclosure disputes do not begin with outright dishonesty. They begin with incomplete memory, poor wording, assumptions, or failure to appreciate that a prior issue still matters even after repairs were attempted. A seller may think, "That leak was years ago," while the buyer thinks, "I should have been told there was ever a leak at all." The disclosure form helps bridge that gap. A strong disclosure form should therefore be treated as a communication tool, not as a nuisance. It gives the seller a roadmap for disclosure, gives the buyer a roadmap for investigation, and gives the broker a structure for asking follow-up questions where answers appear incomplete, inconsistent, or concerning. The condition of the siding. The condition of the siding may look like a small issue on a disclosure form, but in practice it can point to much larger concerns. Siding problems may reveal moisture intrusion, poor maintenance, hidden rot, insect activity, structural movement, installation defects, or prior repairs that did not solve the underlying issue. For example, a seller may describe the siding as having only minor cosmetic wear, but the actual condition may include soft spots, swelling, separation at seams, repeated repainting over water damage, or areas where replacement boards were installed after long-term exposure. To the untrained eye, that may look like ordinary aging. To a buyer after closing, it may become evidence of concealed deterioration. This is another excellent example of why real estate professionals should pay attention to what the condition suggests, not just what the seller calls it. A broker who sees cracked fiber cement panels, bulging wood trim, loose stucco at lower elevations, or patchwork around window penetrations should consider whether additional questions are appropriate. Has there been prior water intrusion? Was there pest damage? Was there a leak at a roof line or flashing detail? Was a contractor hired? Is there an invoice? The condition of the siding can also affect financing, insurability, and future repair costs. A buyer who is planning to occupy the property long-term may view siding deterioration very differently from a seller who has simply grown used to seeing it. That difference in perspective is exactly why disclosure matters: the owner's ability to clear title. Another topic that is sometimes underestimated is the owner's ability to clear title. Many people think of disclosure only in terms of physical defects, but title-related problems can be just as serious. A property can be beautiful, structurally sound, and visually appealing, yet still be difficult or impossible to transfer if title issues are not resolved. Title concerns may involve liens, judgments, unpaid assessments, unreleased deeds of trust, probate issues, ownership disputes, missing signatures, unrecorded interests, boundary issues, easement conflicts, divorce-related claims, entity authority problems, or prior transfers that were never properly documented. If the seller knows of a title issue that may interfere with closing, that information is material and should not be hidden. This topic is especially important in Arizona because disclosure education standards now expressly include the licensee's role in helping clients review title-related materials, encumbrances, and other information that may be important to the client's reasonable interests. Consider a common example. A seller inherited a property from a relative. moved into the home, and now wants to sell. The seller assumes title is clean because the property taxes are current and the house has been occupied without dispute. But if probate was never completed correctly, if a deed was never recorded, or if another heir has a possible claim, the seller may not actually be able to deliver clear title on the scheduled closing date. That is not just a title company issue, it is a transaction issue that can delay or derail the sale. Another example involves a seller who completed additions or transferred interests between family members without proper recording. The physical structure may look fine, but the public record may not match what the parties believe ownership to be. When this happens, a buyer may face delays, additional legal expense, or uncertainty about what is actually being conveyed. For brokers, this is a reminder that disclosure is broader than physical condition. A prudent licensee pays attention to ownership history, title commitments, recorded documents, and statements by the seller that suggest unresolved ownership or encumbrance problems. The broker is not expected to practice law, but the broker should recognize when title issues need to be disclosed and addressed through escrow, title, or legal counsel. Online discussion. Why are latent defects treated differently from defects that are visible during a normal walkthrough of the property? Answer. Latent defects are treated differently because they are hidden and are not reasonably discoverable through ordinary observation. Since a buyer may not be able to find them during a normal inspection, known latent defects create a stronger disclosure obligation for sellers and licensees. Why do disclosure failures lead to so many real estate lawsuits, even when the property problem itself may be repairable? Answer. Disclosure failures lead to lawsuits because buyers often feel they were denied the chance to make an informed decision. The legal dispute is usually not just about the defect itself, but about whether someone knew about the issue and failed to disclose it honestly and completely before closing. Why is the condition of the siding more important than many sellers first assume? Answer. The siding may reveal larger problems such as moisture intrusion, rot, insect damage, or prior repairs that did not solve the real issue. What appears cosmetic may actually point to structural or maintenance concerns that a buyer would consider important.